We move on then to consider the third head of charity, that is to say, advancement of religion. Now, some may think that the law is remarkably tolerant of various types of religious purposes, and it certainly is true that a very wide view of religion has been accepted by the courts. It may be that the reasons for this lie in the mortmain legislation between 1736 and 1891, which, as we have seen, made testamentary dispositions of gifts to charities void. Therefore, to construe a purpose widely as a charity may not have been to the benefit of that purpose at all, but indeed quite the contrary, that it would be held void under the mortmain legislation. Examples of religious purposes certainly extend to the unorthodox Christian, or if you like, the Christian fundamentalist. We've already seen the decision of Thornton and Howe in 1862, where a trust to promote the purposes, the writings of Joanna Southcote, who was a fundamentalist Christian, was regarded as charitable. And in more recent years, something similar happened in Re Watson in 1973, concerning the works of one Mr. H.G. Hobbes, works which hardly anybody had heard of. He was certainly not a well-known Christian, but was nonetheless essentially a fundamentalist Christian person. You can see that Joanna Southcote was regarded, in the judgment itself, as being a foolish and ignorant woman, who laboured under the delusion that she was to be made the medium of a miraculous birth. Nonetheless, a trust to promote the writings of Joanna Southcote was regarded as charitable. As we have seen, the effect of this was to invoke the mortmain legislation, still in force at that time, and to render the testamentary disposition of land void. The law is also tolerant of other faiths. Thus, for example, in Neville Estates and Madden, which concerned a Jewish synagogue, Mr. Justice Cross said, "As between different religions the law stands neutral, but it assumes that any religion is at least likely to be better than none." And in Bowman and Secular Society, way back in 1917 in the House of Lords, Lord Parker of Waddington had thought that a trust for the purpose of any kind of monotheistic theism would be a good charitable trust. In more recent years, faith healing has been held to be a charitable purpose in Re Lecran Clark, although it is fair to say that faith healing there was at least in a Christian context. In Re Watson, which, as we have seen, involved the works of one Mr. H.G. Hobbes, a Christian fundamentalist, the view was taken that the court assumes that religion is a public benefit unless the contrary is shown, really whatever religion it is, that the law does not distinguish between one religion and another, and unless the purposes, or the doctrines rather, are adverse to the very foundations of all religion, and that they're subversive of all morality, unless that is the case, the purposes will nonetheless be regarded as charitable purposes. Nevertheless, there are limits to the concepts of religion. One is that it has to involve a supernatural element. Simply relations between humans and humans are not regarded as charitable for the advancement of religion. Consequently, in the case that I'm going to call YCN, because of my very poor pronunciation of Pinyin or Chinese, the Privy Council held, way back in 1875, that a direction for the performing of ancestor worship in Malaysia was not charitable. This, I think, was an unfortunate attempt to export the English law of charities into an unsuitable context, because ancestor worship is, or at least was, quite popular and common in that part of Malaysia at that time. More recently, in the South Place Ethical Society case in 1980, the advancement of ethics was held to be non-charitable. This case arose for the purposes of rates valuations. Ethics are about man's relations with man, and are not about man's relations with God. Religion, on the other hand, requires something, as I say, supernatural, something about a relationship between man and some supernatural being. The third head is also for the advancement of religion, not just the practice of religion, but its advancement. And of course we have to remember that there is also a public benefit with all heads of charity, and a religion that is practiced wholly in private is not going to amount to any kind of public benefit. That was decided by the House of Lords in Gilmore and Coates, which we'll look at in more detail in the public benefit lecture. The Freemasons failed on these grounds in the United Grand Lodge case in 1957. Because Freemasonry is, after all, essentially a secret kind of organisation, and they engaged in no kind of teaching or promotion of their religion, although they did practice it. That was not regarded as being enough. Nonetheless, it has to be said that the requirement for advancement is not a particularly onerous one. Mr. Justice Cross, in Neville Estates and Madden, thought it sufficient that the people who went to the synagogue also lived in this world and mixed with their fellow citizens, so that, if you like, they could advance religion by example. Conversely, in Re War's Will Trust, a slightly earlier decision, again a decision of Mr. Justice Harman, it was not regarded as charitable to provide a house of retreat for meditation and spiritual renewal, even though people would presumably come out into the world again later. Actually to provide for something that was being done in private could not be charitable under the third head. The Charities Act 2006 for the first time includes a definition of religion, and as you can see from the PowerPoint slide, it includes religion which involves belief in more than one God, and also religion which does not involve belief in a God at all. Nonetheless, I do not think this actually widens significantly what we've already been talking about. This seems to me to be likely to encompass Hinduism, for example, and Buddhism, which may not fall into the traditional monotheistic categories. I don't think it removes the supernatural element from religion, and doubt very much whether it would allow promotion of atheism to be regarded as for the advancement of religion for charitable purposes.